on for, looks like there was a contempt found, there was a motion to reconsider, and that was granted, and so the contempt was set over to today.
Yes, Your Honor.
All right. And I did, let me just, this was contempt regarding the quadro and how long it took to get that done. Am I correct on that?
Yes.
Okay. All right. So then I've reviewed the motion. I reviewed Mr. Kreiderman's declaration and request for the reconsideration. So any argument?
Just briefly, I'm Megan Gilmore on behalf of Kreiderman. This was before the court on May 23rd in front of Commissioner Nelson, and the court did find husband in contempt and awarded $1,500 in attorney's fees. I reviewed the motion declaration for reconsideration, and the basis for the request was an allegation that Mr. Kreiderman wasn't able to get online and defend himself at the hearing due to some sort of technical difficulties. I think that's an accurate summary of the allegation. However, I was somewhat confused by that, as Mr. Reed did appear on his behalf as referenced within the hearing notes. And so based on, again, it looks like Commissioner Nelson's basis of his ruling on the reconsideration was the fact that, again, Mr. Kreiderman wasn't able to respond to the motion, which I don't believe is accurate. I do acknowledge the fact that he has reconsidered the order and then that this needs to go back before the court. I think my motion is very straightforward and clear. These parties were divorced in February of 2022. Husband was required to pay all costs relating to the drafting of the quadros and do so in a timely manner in good faith to get this done and completed. As explained within my client's declaration, she has very limited means. She is disabled and her net income is less than $1,000 a month. So she was relying on this quadro to be entered timely, and that was the basis of the agreement. We brought this motion after 13 months of this order being entered, and I've attached numerous exhibits of my client, or me through my client, attempting to get updates through husband, through his counsel. I can provide updates to the court that the quadro that was entered with the court, I was trying to find it before we were called, just shortly before the last hearing. That was subsequently denied by the pension plan. That's going to have to be redrafted. I contacted Mr. Reed and indicating that some time ago. I haven't received a draft of that order, but that still will need to be addressed. The 401k quadro has been drafted and it was sent to be pre-approved by the plan, I believe, last week. But at this point, we have no final orders still entered. My client, since moving firms, I've only been dealing with this issue alone, this post-decree quadro issue, and my client's been charged $3,817. So again, my client simply wants the orders to be complied with. She doesn't want to have to keep going before the court. She needs relief as to attorney's fees. We do believe that the violation was willful and intentional, as acknowledged by Commissioner Nelson at the last hearing. It was there's a note that nothing really moved until we brought this motion for contempt, despite my multiple requests, multiple telephone contacts to get this prompted outside of the motion. So outside of the motion, we still would be without a quadro. So we do ask the court find him in contempt for a second time and enter a award of fees in this case.
All right, thank you. Mr. Reed, have you filed a notice of appearance in this?
I haven't, Your Honor. I think that's probably part of what is the issue here is I have I'm representing Mr. Kreiderman in a limited capacity just to draft the quadro. I was not aware that there was a reconsideration filed. I would defer to Mr. Kreiderman since apparently that's the crux of his argument is he would like to speak for himself. I would defer to him on that issue.
Okay. Yeah, before I turn to Mr. Kreiderman, the pension quadro that was rejected, has that been redrafted?
I don't believe it has been redrafted, Your Honor. I'm going to have to take a look at my records. I know that we sent the one off to the plan for approval, but I don't recall that we had done the second one yet.
Okay.
I'm looking it up, but you can address again, right. Mr. Kreiderman.
All right, Mr. Kreiderman, if you could unmute and any argument you'd like to make.
Yes, ma'am. The lawyer I had before hired us after when the divorce was final said he was going to take care of the quadro and the pension split, and then come to find out a couple months later we had some more go in the court something, and he'd plumb forgot to get it started, and that was of April or May of last year. So he started the process, and the last time I talked to him about it was in September when he told me he was having a lot of issues with my company getting it done. And then the next time I heard from him or on anything on this was when I got served paperwork for this contempt of court. So I went to my lawyer to find out what's going on at the time, and he come find out he dropped me the day before I got served with this paperwork. So he had the pension split paperwork done, so I signed that, and it got sent in. I didn't know it got denied. I just now found out it got denied, so I'll have to hire Mr. Reed to complete that. I only hired Mr. Reed to do the quadro split, and I was representing myself on the court. That's why I did the rehear this. And I was not notified by my lawyer what was going on. He didn't even email me, so I was kind of in the dark when I got hit with all this in the middle of April. And I've been working my butt off since then to get the stuff done. So I'll have to Mr. Reed, I'll talk to him after this and get him situated to take care of the split on the pension. It's obvious my other lawyer wasn't doing the job or didn't know how to do it because it didn't get done. And I don't have the money to pay that much money right now.
All right. Anything else, Ms. Gilmore?
There's still difficulties with his prior counsel. However, he did have a notice of appearance in until relatively recently. So obviously I have an obligation to communicate with Mr. South. I don't have any information that he didn't forward that. Only communication I did have from Mr. South was he was having difficulties communicating with his own client. Obviously, I don't know what was happening between their attorney-client relationship. The facts of the case are is that he entered an agreed order. He was where he had an obligation to get an order entered, and he failed to do so. I mean, the simple fact is he wasn't communicating with his attorney either way. And so my client was injured in the process, and we believe that it was willful intentional. The same thing is being done now on the second quadro is, I think I can give the court more information, but I contacted Mr. Reed some time ago with information that the pension was rejected. Again, he has a notice of appearance, and again, I don't have the ability to communicate directly with Mr. Kreiderman. And again, we do not have an order entered. So my client continues to be prejudiced in the meantime.
And Ms. Gilmore, you didn't present an order for today, is that correct? I just want to.
No, I was based on reconsideration. I was waiting for basically another ruling.
Just want to make sure I didn't have it here. All right, so I am going to be very honest and sympathetic with Mr. Kreiderman. When we have an attorney, they have, we instill a lot of trust in those attorneys to make sure that they're following through with the things that we believe that they're following through on. But that does not completely take away our own responsibilities to make sure that those things are being done when you're the one on the line for it. So it appears to me that this quadro was ordered I don't know, February of 2022. And so here we are in June of 2022, we're 2023, excuse me, we're still don't have a quadro in one because it was rejected, and was a recent submission of the quadro in the other. I am going to make a finding of contempt in this case. Ms. Gilmore indicated $3,800 approximately that has been spent trying to get this quadro entered. I understand that frustration as well. So I think, unfortunately, we're back where we were under Commissioner Nelson. So I'm going to find a contempt, and I'm going to grant the $1,500 in attorney's fees. So that's something you can submit.
It's already drafted. So
okay. All right. Hopefully this can get taken care of sooner rather than later, and then we don't have to worry about it again.
My only question is, can we set a review just to make sure that I don't want to have to do another motion? Mr. Reed, when do you think you can draft the pension and be having a meaningful review?
08.
I imagine we can do that within a couple of weeks.
Okay.
On for review of GAL.
Noel McLean appearing on behalf of the petitioner, Colleen Gilman.
And Christine Dow appearing on behalf of the respondent, Tristan Gilman.
All right, where are we at?
So, Your Honor, we are still waiting for information on the mental health evaluation. This updated GAL report really centers around the father's mental health and the concerns that have been raised about that. He is seeking services with Core Health, but we've had extreme difficulty getting through with them. I've been in touch with the attorneys. The attorneys have been in touch. I'm not sure what it is the court would like to do to move forward. I'm kind of stuck. I can certainly move forward with home visits and meeting with the child's counselor, but I was really waiting for the father's information because this centers around his actions and behaviors.
So was he undergoing an evaluation as part of this most recent requests, or is it just records from, hold on one second.
He completed his portion of the mental health evaluation that was ordered in this current round of orders. I believe it was on April 12th. He provided contact information directly to Ms. Gilman on May 8th. Prior to that, he told Core that they needed to reach out and speak to Ms. Day and to Ms. Gilman. I spoke to the core office this morning to ask them why they haven't followed up on any attempts for Ms. Day and Ms. Gilman to reach them. They haven't returned any phone calls. I do not know what's going on there. I spoke to someone there who gave me a cross my heart and hope to die that not only would the evaluator call me, but the clinic manager would call me this afternoon, and I have not heard from them yet. I don't know what to say about it. My client completed his part. I confirmed that there are authorizations and instructions to contact Ms. Day and Ms. Gilman, and I don't have much else to offer.
And I can tell the court from my client's perspective, she too has also reached out to CORE. She has not received any responsive information. My staff has continued to communicate with Ms. Dow and her staff about follow-up. Our concern obviously is the fact that our original request was for the court to reduce time between this child and Mr. Gilman because of the presentation and the difficulties that the child was experiencing. While I sympathize with the fact that we have a provider that is not responding, the concern really is with reference to this child, and it is, just as you indicated in the case before us, it is the client's obligation to make sure that they're following through with what needs to be done. Mr. Gilman is not currently employed. This would be his main #1 objective, is to make sure that people are following through with what they need to follow through. And clearly he's not camping out there trying to ensure that they're complying with this. But again, that leaves us in a precarious position with Mr. Gilman and the fact that we're sort of at a standstill, much to this child's potential detriment, since we don't have further information of what's going on with his mental health. When we were last before the court, you had entered the amended temporary parenting plan back on March 21 of 23. And that's the order that you entered that required Mr. Gilman to undergo the independent mental health evaluation and to consider input from both my client and the guardian ad litem. That's been in place now for 3 months, and we don't have movement forward. So that's concerning to us. The other concern that I've also discussed with Ms. Day is that recent bank statements from discovery documentation may suggest that Mr. Gilman is using substances such as marijuana. My concern with that is, given his depression and the mental health issues that presented back in December as a crisis, if he's now attempting to self-medicate, that may be a huge concern as well. I guess at this point, one of the concerns that I would ask is that the court consider ordering Mr. Gilman to undergo a hair follicle test today. We would ask, if you do that, that be at his own expense. I would remind the court that on March 14th, you entered a contempt finding against Mr. Gilman for his non-payment of child support, and he currently owes my client about $6,600 in child support arrears. My client has limited finances, and she's trying to follow up and do everything that she needs to do as far as being a participant in his evaluations. But at this point, those are the concerns that are coming out of this. And at the core of this is the fact that we've got a 6-year-old child who has most recently, at the time you last heard this, indicated reticence about going to dad's house. You have a father who is not employed, who is addicted to gaming, where you have had to put ordered restrictions on that gaming, and who is not committed to securing appropriate permanent housing. So all of those things, I think, when taken as a totality, are concerning issues that here we are 3 months later, and there's no movement forward by this father.
My client has had no better luck with CORE than Ms. McLean has, than Ms. Day has, than I have. I did, as I said, I did speak to someone directly today. I now have the name of the evaluator. So between my client and I, we can, as Ms. McLean characterizes it, sort of camp out on their doorstep. But in the meantime, we have these concerns that were raised initially. We don't have any further information except what's been presented to the court so far. My suggestion would be that perhaps Ms. Day could start with the home visits, start with talking to the child, and I can commit to, I've been having problems with CORE in some other cases as well. I can commit to chasing them to get that information so that we can get the mental health evaluation.
Right.
As Ms. Day said, it kind of centers around that. And I'm not sure what else we should do except have her maybe go on with some of the other components of this until we get it.
And Ms. Day, have you started anything else with this case?
Just, I've spoken with both of the parents. I have an existing relationship with them from the prior GAL report. So I've talked with both of them a couple of times and exchanged information with them. I've reached out a couple of times, like I said, to CORE, as well as to their records request, hoping even that might spur things along, and then reached out to the child's therapist. And I will continue to do that. But I have not met one-on-one with the child. I was kind of waiting to see what I got from the mental health aspect of that first, but I certainly can move forward with that.
I'd like you to. Here's if there's concerns in a roundabout way, it sounded like Ms. McLean was raising some concerns. Some of them may be new. Some of them I think they've been worried about for months now. So I'd like that to start. What I'd also like is let's set a review for the 18th of July.
Unfortunately, I'm going to be out the 14th through the 31st.
Well, we already have an August 8th review. So let's just keep the August 8th review. If there's obviously any concerning issues, Ms. Day, by all means, noted on prior to that. I know Ms. McLean is going to be out for a few weeks at the end of July.
Absolutely.
But
I'll have my laptop with me.
Okay. I'd like to try to forge ahead with as much information as we can get in the meantime and see where we're at. And if anything pops up, by all means, bring it back before the court. But I think status quo, I unfortunately agree with Ms. Dow. Some of these agencies either just are really non-responsive recently and or overworked and or whatever excuses we want to come up with. But it's not an uncommon problem. And I don't want, I'm not necessarily putting blame on Mr. Gilman for that issue. So let's keep our review date of the 8th. Any concerns that arise, bring it before the court prior to that. And we'll just maintain where we're at. But yeah, Ms. Day, if you want to just get it started on everything else, and then hopefully you can backfill with the information we get from court.
Absolutely.
All right.
If there are concerns, is the court, would you be willing to consider even Ms. Day just looping us all in on an email, and then we could file that thread with the court?
I don't have a problem with that as long as everybody, Ms. Dow doesn't have a problem with that.
No, I have no problem with that.
Okay.
Okay.
And then what about the request in regards to him doing a hair follicle?
Tell me why, based on financial records, you are worried about that. And
so the bank statements that I received through Discovery have a number of payments, as it were, exchanges at facilities that would be either marijuana related or could be CBD, whichever. I discussed those specifically with Ms. Day. They included, one is Hempberry, which I think she identified as potentially a CBD location. There is, I guess I should have had these, sorry. Erupted vapor, there's a number of those for erupted vapor, which apparently is located here in Longview. There is, I thought that there was another one besides the Hempberry. I think it was the Smoke Shack. I have to find that one again. But these are all this year that there appear to be Welch's Smokes in Welch's, Oregon. And then the Hempberry here in Kelso. But the concern is with the incident that occurred in December, if he's self-medicating since then, when he's supposed to be participating supposedly in this Wounded Warriors program and under other medication use, one would suggest that that's contraintuitive or contraindicated with ongoing mental health medication use.
And Your Honor, there's, I mean, as Ms. McLean says, we don't know if these are for purchases of CBD products. I know my client has some pain issues. There's no indications anywhere that A, he's self-medicating for some sort of a mental health problem, and B, I don't think there were any prohibitions on marijuana use in the previous parenting plans. So asking for a hair follicle test at this point, I mean, he hasn't made any statements one way or the other about whether or not he is using marijuana and what he's using it for.
At this point,
we could find out, and the guardian ad litem could certainly ask.
at this point, I'm not inclined to grant a request for a hair follicle. I don't see any prohibitions in the plan. I understand the concerns. but without some additional information, if Ms. Day finds something that is concerning and requests that, I'll happily reconsider. But at this point, I'm not going to order a hair follicle. GAL report, which
right.
I received and have
Thank you.
reviewed. And do we have, Mr. Davis is here. You received that report?
I did, Your Honor. Sometime last week, I reviewed it with my client, and I'd like to be heard on that report when the court's ready.
Sure. And Miss Ellis is here.
Okay.
All right. So Miss Ellis, did you receive a copy of that report?
Yes.
Okay. All right, Mr. Davis, go ahead.
Your Honor, I know you read the report. I won't repeat it entirely. We want to thank the GAL for the report, especially in the time the court gave her to do this interim report. My recollection was this report was simply an interim, or we expect it to possibly be oral, regarding whether the supervision should continue or not, in this case, pending a final report down the road. It's our understanding that she is recommending supervision continue. We object to that. The basis of that is my recollection and understanding from all the previous allegations is it was a close call. The court wavered whether it wanted to put supervision or not, but there was allegations about Joseph that were concerning, admittedly, if they were true. And so the court erred and, used caution and put supervision in place. As the GAO report indicates, it looks like the parties have agreed to let Joseph not do visits right now until he attends reconciliation counseling and whatnot. So really the visitation at this point is only among the 4 other younger children. As the court may recall, this was a situation where the parties separated in October of last year. Father had regular visits with all the children, including overnights, except Joseph, through May until the court put supervision requirements on it. Again, it was unsupervised by agreement of the parties throughout that process. Our opinion is that supervision should go away as to the 4 youngest children. At some point, if Joseph resumes visitation after, supervision, or reunification counseling, then that, we guess we could discuss that, or just put that in the plan and reserve it automatically. If he has visits, that's to be supervised. But we don't believe there's a basis otherwise, because the allegations were almost, if not entirely, about Joseph. As you might understand, this is a severe hardship on everyone, including all the supervisors that have to do these visits. And so that's our request, Your Honors, to resume unsupervised visitation at this time, and pending the further report. The report itself was based primarily on father, it appears, because that's what the court's instructions were, an interim report regarding supervision, where you look forward to the additional report regarding mother and the parenting of both parties, et cetera. We would normally see in a final report. But until then, we don't believe supervision should continue as to the 4 youngest children.
All right. And Mr. Davis, you're indicating that there was a switch from unsupervised to supervised. I only show that one parenting plan and it's always been supervised.
Let me clarify that, Your Honor. No, the court's order was supervised on that parenting plan May 16th. The court's never ordered unsupervised. What I was referencing is the parties separated in October of last year.
Okay.
One of the parties filed earlier this year, Mrs. Ellis. Until our hearings in May, I believe it was, supervision was never requested from the court, or certainly ordered by the court, regarding the children, and father enjoyed visits for that 5 or 6 month period, without supervision. And so the extent of the allegations were about Joseph, and that's why the court's order itself on May 16th and the signed parenting plan required supervision. But since Joseph is not visiting currently right now and going to go through reunification counseling, we don't believe that is needed as to the 4 other children, at least.
All right. Thank you for clarifying that. Miss Ellis, do you have any response?
I think the 2 youngest would be fine, but the 3 oldest, I think would still like the supervised visits, is what I understand from them. I think from the beginning before court, yes, they were obviously unsupervised because we never went to court about it, but attending court, whatever, that was, the first ruling was supervised visits. And so Joseph's not the only one that was affected. The 2 older girls were affected too. And the Carly asked me, why does she have to visit her dad? Because she witnessed, the incident that happened.
Okay. All right. Thank you. Ms. Turnbull, anything you want to state?
Well, I do think getting a little bit more information from the domestic violence assessment will be helpful. Carly did specifically say to me that she would like the visits to continue to be supervised. Rosabella did not state a preference either way, but given the history with Carly and Joseph that gives me some concern for Rosabella as well. Fathers, I think I mentioned in the report, some of his collaterals did express concern for father's discipline. And so that was one of the things that gave me concern. And the younger children may be okay, but if father's under stress with all of the kids, that is a concern I have.
All right. Well, here's where I'm at. I'm not seeing anything that would make me change to unsupervised at this point in time. I understand everybody's position, and I respect everybody's position. I frankly wouldn't be opposed to the splitting it up, the 3 eldest supervised, the 2 youngest unsupervised, if I didn't think it would be a complete and total logistical nightmare. There's already been all the concerns, maybe transporting 4 kids versus 5, since the eldest isn't participating in visitation, has helped a little bit with that. And I understand that there's the good graces of other folks that are supervising this. But until I have more information, I think I'm going to leave everything where it's at. If the parties, so if Miss Ellis and Mr. Davis have a conversation and there's an agreement to have the 2 youngers sort of split out from the 3 elders to do a different visitation unsupervised, and the parties agree to that, I'd happily sign off on that. But at this point, in the middle of a docket, knowing how difficult it was to find the times and places for all 5 kids to have visitation, I'm going to leave it as is. If Miss Ellis and Mr. Davis, you want to put your heads together and come up with a plan for the 2 youngest to have unsupervised, that's great. And it sounds like the GAL is more concerned about the 3 eldest as well. So those 3 will remain supervised.
The GAL recommends father attend domestic violence evaluation, which is already completed. We just don't have the report yet, to my knowledge. Secondly, she also recommends that Joseph, the oldest son, who most of the allegations are related to, attend reconciliation therapy. We're asking the court that the court require that, and we recommend Molly Tapney, who is a licensed counselor in the state of Washington, is my understanding, and both parties are familiar with her. I don't know Miss Ellis's position on that case, of course, but that was our suggestion. But the main thing is to require Joseph to go through reunification counseling, and obviously, father has done everything to comply with Ms. Turnbull, and certainly would continue to comply with whatever Ms. Tapney or whomever the counselor is, so that process can get moving forward as quickly as possible.
Any position on, and I'm sorry, I didn't catch the name of the individual that Mr. Davis proposed, but
Yeah.
reconciliation therapy.
Yeah, Molly Tapney. I know Joseph's really opposed to any sort of counseling right now. He's still, I think, has a lot of things to work through. So I don't know if we can just go into it gradually, or maybe take some more time and then do it. But I don't know if it would just push him away further. I'm not sure.
I understand her concerns, Your Honor. However, I don't know that we get anywhere, certainly with the court continuing supervision requirements as to the other older children at minimum. Again, based primarily on the Joseph situation, we're asking the court to require them to participate in that. Whatever the counselor says or what that involves, of course, would have to be determined. But otherwise, it doesn't sound like he's going to do it. And so we're stuck. Our hope is that some of this can get moving forward. Obviously, the DV evaluation, I think, should be completed any day now, but we need a lot of this to get done before the final GAL report, if possible. Reunification counsel, of course, may obviously go beyond that, may go on for who knows how long, but that's our goal. I mean, our goal is to get unsupervised and more time again, like we previously had. And right now we're really limited.
Final order, August 16th. Okay. Sorry, I was looking for that next date in the GAL report. So historically, teenagers, my experience with teenagers, and I have a fair amount of that with my prior position, forcing counseling 9 times out of 10 doesn't work. I understand you're in a position a lot of times where you need to force it in the hopes that it does work. And when I say counseling, I'm not talking about, drug and alcohol, that type of stuff. I'm talking about, actual counseling and different mental health type services. I'm sure the event was rather traumatic. I am a little deferential to Miss Ellis and her concern that maybe it's a little too soon to start that. And frankly, I mean, if we're going to just get down to brass tacks, the person that Mr. is it Joseph is the oldest, that Mr. Joseph Ellis is going to blame for any of these issues is going to be Mr. Ellis. And so that's not a position I'm sure he wants to be in either, but I understand he wants to see his son and work those things out. I'd like to do kind of more of a graduated thing. So what I'm going to, Miss Ellis, I'm going to indicate, and I'm going to ask Ms. Turnbull to sort of help with this process. I'm not opposed to whomever the parties can agree on, if they agree on anyone. But let's give it a few weeks, and let's set Joseph to, let's try to get a first appointment in with a counselor by July 28th. And just see how that goes and start the process, provide feedback to Ms. Turnbull. If that goes well, then let's move forward with reunification counseling. But frankly, there could be other things going on that need to be addressed before we worry about reunification counseling. So I want to make sure, but I also know that kids can be very oppositional in these situations. And I do want to ease them into it. There's some choices that he can make and some choices he can't make, unfortunately. But if I force him into counseling right away with Dad, I'm not the bad guy. Dad's the bad guy, and we don't want to set him up for failure that way either. So, Miss Ellis, if you could get him into an appointment by the end of July, get some feedback from that individual. So if we could do a ROI with Miss Turnbull, so she can incorporate that information in, and if we can segue and start reunification counseling shortly thereafter, great. If not, we'll address it when we return on the 16th of August.
That matters, right?
All right. Do we have, is Kelsey Demeter still involved, or is she no longer a part of this?
She has withdrawn.
Okay. All right. So we're here on contempt. I have reviewed the contempt. I have also reviewed, I believe there was a response.
There was.
And I'm ready for any argument.
Very good. So this is a straightforward contempt regarding child support and non-payment of child support. The order of child support was originally a temporary order that was entered in November of 2022. That was followed up by a subsequent final order of child support, I believe, in January of 23. From that original order in November of 2022 through essentially the current date, there's been no payment, no attempts to pay, no plan to pay, and that continues with the reply. We calculated the arrears just through April, because that's essentially where we were when we filed the motion, at $2,532 plus interest. The complaints really are just not grounded in reality that were filed in the reply. There's this sort of allegation, well, they didn't consider my other children, but if you look at the final order of child support, there is a whole family deviation that's already included. The parties considered transportation. This was an agreed child support order. This was no one was forced to sign this. This was an agreement. It did give consideration to those things that are essentially complained of now. The other excuses again fall flat. Well, Jay was in the hospital. Okay, that maybe explains a week of the 8 months. It doesn't explain 8 months. She was only in the hospital for, I believe, 2 days. So again, where we are is just a simple. And when you look at, again, her statements, there's no plan to pay. There's no, hey, put me on a payment plan. There's just, here's a bunch of excuses and no plan. So we're asking the court to award the full amount of arrears, the full amount of interest requested. She should be required to pay her child support in full and $150 towards the arrears going forward. That's reasonable. That's still going to take her more than a year to pay off that arrearage. As far as the taxes, again, the petitioner in this matter claimed the children for the 2022 taxes. She should not have. Both in the November 2022 order and the final order, my client was to claim the children in even numbered tax years. 2022 is an even number tax year. She was contacted essentially before she filed, said, hey, my client's saying, hey, this is my year to claim. She then runs out and files first, and then my client can never get relief unless she amends her taxes. So again, my client's the primary parent in this case. He was ordered to receive those, and he should have received them. Even if it was her year to claim the children, she could not have because she's not current in child support. So even if it was her year, still not appropriate. There's really no circumstance where it's appropriate that she has claimed them. She continues to refuse to amend her tax return. We're now 6 months in. We made substantial efforts to gain compliance. Contempt was not our first step. We made efforts. My client made efforts. She just ignored all of those and said, I'm going to do what I'm going to do. And that's not appropriate. In this regard, we're asking the court to order her to file an amended return, removing the children from her return, that she needs to file that with the IRS, provide proof she's filed that with the IRS, and provide a copy of that return to this court. We'd like to see the court set a review so we can review that she's paid child support, and additionally to make sure that she's paid or that she's filed her amended tax return. I think that that's appropriate in a case where we really have somebody who's been obstinate for, at this point, we're at 8 months in, where somebody's just saying, I'm not going to comply. So with that, we're asking the court to find the arrearage through April of $2,532 plus the interest on that, $1,000 civil penalty. Essentially, we have two very clear contempts here, and just an unrepentant, obstinate individual on the other side. Fees of $3,500. Again, efforts made to resolve this before, and you also see that I had to go through extra efforts to get her served and file motions to serve her by mail, and $130 of costs. We're asking the court to order all of those as well as set a review.
Okay, just quick question. What was the amount that you said was in arrears?
So just through April. So based on when we filed, we just went through April. That's $2,532.
So
and then
the 3981 is current.
Yes.
Okay.
And in addition, my client, because the Division of Child Support, we put in an additional declaration. It takes time from the time that the order is entered until the Division of Child Support actually starts acting on it. So my client was continuing to be garnished, even though he was then had no obligation to pay, and actually with the primary and custodial parent at that point. We're also asking for a judgment of $923.52. That's from the time period of essentially November 7th through December 12th. We provided all of those wage stubs that show the garnishments that were happening even after the court had placed the children with my client.
And that's that plus the current amount is the 3981 in your contempt order.
Yes.
Yes, Your Honor. The reason why I wasn't able to pay prior in November, which was stated in the previous casework and everything, before we came to a settlement, was the visitation schedule mixed with the fact that I live in Everett and was having to drive down to Longview area for visitations. I think it was like 3 times a week, which would leave me with no time for work. My husband was having to call out of work to take care of our other child in that time, which was making us lose money in that instance as well. We have been scraping by because I later found out I was pregnant and was put on bed rest due to extreme nausea and a couple other things that were going on in the pregnancy. For the first trimester, it lasted a little bit further into the second trimester. I had an emergency appendectomy, which did land me in the hospital with emergency surgery. Once I was out of the hospital, my midwife required that I stay resting and recovering with a very minimal weight limit for the next month or so. The entire time I was still applying for jobs. I was still looking for work, whether it be at home work or light duty work. Got very minimal responses back, unfortunately. Had an interview scheduled the day I had to have my surgery. It got pushed out when I contacted them again. That position had been filled. Regarding all of that child support back then, I have been working since April 14th, I believe, is when I was officially hired, and have been working pretty much every single week since then, minus having to cut back hours due to more pregnancy complications, to where I was passing out at work and such like that. Child support division have tried to get in contact with my employer. I have given them my employer's information. I have been in contact with the Division of Child Support, making sure that it would get taken out of my paychecks. She pays through Gusto, so I don't see pay stubs. I don't get pay stubs. I just see, this is what amount you get. Okay, cool. So in my head, I'd already calculated that it should have been pulled out and didn't even think about it. The times that I was had been tried to be served, I was at a wedding, my sister's wedding out of town. I was at work or driving between work to pick up my child, which is in the next town over, to come back. And the other time that would have been able to catch me, I was in the hospital with my son because he had kidney stones. On top of that, the tax return matter, I was advised with my legal counsel at the time, misdemeanor, to file because I never got served any paperwork or informed of any paperwork or given copies of any of the paperwork from November 22 or whatever it was. And so I didn't know that it was already in place saying that he would claim them for the odd numbers. I was not aware of that until, or the even numbers, my apologies. I was not aware of that until the rebuttal just now or the previous one. I have not seen that paperwork. I still have not seen it. I am under the impression that with my legal counsel at the time that I had every right to file. That is why we filed. I'm still very new to all this legal stuff, so I didn't know that I couldn't file if I was not caught up to date on child support. And to my knowledge, I didn't know that I was supposed to be paying from November. I thought it was started in December. I didn't even know that I had a missed payment. And I have had to take time off to try to find a lawyer and to my apologies, and to attend these court hearings and to drive down to Longview to even turn in paperwork, which is costing me more money that I could be giving to the kids, which I'm sorry, I'm very frustrated. That I'm trying to get to the kids because I know that they deserve that, and I'm trying to be able to support them on top of the gas money that I have to pay. If I didn't have to pay the entire amount for driving them back and forth, which I tried to resolve with the first settlement, we went back and forth on that. If I did not have to pay the full amount, I would be able to give more and make sure that the kids had money. It also has put a lot of strain on my vehicle to where I've had to have repairs done. And I honestly don't see why anywhere in the paperwork where that would have been taken into account with the child support.
So I'm going to object. We're really far beyond her declaration. I've let it go for quite some time, but we're far beyond.
All right. Here's where we're at. I'm going to use kind of a phrase I hate, but ignorance of the law is not, unfortunately, an excuse. You were represented by an attorney. There was a temporary order of child support that was entered effective November 1st, 2022, indicating an amount of support, $300 a month. That was drastically reduced from what was supposed to be paid because of a whole family deviation. And that was also, you were given the opportunity to pay that in 2 portions a month instead of just once a month. So that was entered in November, looks like November 4th is when I signed it. And notes indicate that it was reviewed on the record. Your counsel was present at the time. Additionally, there was an order in place for the taxes. So here's where we're at. I guess thinking that it's taken out of your paycheck and that it's cool probably isn't sufficient moving forward. I am going to make a finding of contempt. I am going to require that you amend your 2022 income tax returns to not include the children or child, excuse me, is it child or children? Children. So Desmond and Amelia. And you will need to file proof of that amended return with the court and on Ms. Baldwin's office. You were receiving support when you were supposed to be paying support. I don't know if you noticed that, but that was, that could have easily been kind of siphoned back the other direction. I'm going to enter the judgment of the past due child support and the overpayments by Mr. Gilliam in the amount of $3,981. I'm not imposing a civil penalty. I will impose the cost of $130. And at this point, even though frankly it's not helping Mr. Gilliam, I'm not going to impose attorney's fees either at this point. So I don't think, I think we'll be back here again. Time frame, I guess, Ms. Baldwin what's a reasonable time frame if you know for to get an amended tax return filed and proof back to us? Is that something that 60 days is sufficient?
Oh, she doesn't have a complicated return. So honestly, I think 2 weeks is sufficient. So I would order her to have it completed in 2 weeks and then review it in a month or so. That also can allow us to review where child support's at the same time.
Okay. So we'll review this case, Ms. Stockwell, July 18th.
I'm here on behalf of the petitioner, Sean McGill, pardon me.
All right. And Luana McGill is present. You can hear us okay?
Yes, I can.
All right, thank you. All right, we are here on a contempt. Let me just, my computer has been awfully slow today, so I apologize. So filed back on, I think, May 22nd. And in regards to the USAA account, hold on, I have notes on this. The USAA Visa debit account and the Navy Federal Credit Union savings account. I have reviewed the declarations, the response, the SIR reply, and I am happy to hear any argument.
Yes, so may it please the court, on behalf of the petitioner, Sean McGill, we are asking that the court enter a finding of contempt. I do note that Ms. McGill in her responsive documentation attempted to bootstrap up some suggestions that my client should be held in contempt for various issues. I would simply ask that the court strike those considerations, one, because there's no motion filed before the court, nor an order to show cause, and I would suggest that that's not properly before the court. I would like the opportunity to provide responsive argument if the court is somehow going to consider those, but I think it's fairly basic, the two issues that are before you. One is Ms. McGill's unilateral removal of $5,000 from Lexi McGill's, their daughter's bank account. There was absolutely no notice to my client. There is restraining orders in the temporary order where the parties are required to protect the assets that are before the court in this case. Ms. McGill attempts to suggest that my client was going to take the monies, and of course there's absolutely no evidence to support that claim. This matter has been pending before the court since 2021, and what you see from the bank statements are in fact deposits on behalf of Lexi. Obviously, parents have not only a fiduciary duty to the community, and obviously compounded by the fact that we've got court orders that require that they maintain assets on behalf of the community, but we also, parents have a fiduciary obligation or duty to their children as well, and that's to safeguard their children's accounts. It is very concerning, particularly in light of Ms. McGill's bank statements and what appears to be her own discretionary gambling, that if anybody potentially is at stake of harming Lexi's financial future, it would be her mother. I remind the court that at this juncture, Ms. McGill has no relationship with her child. Lexi has had a strained relationship with her mother, and they have not had a visitation or contact fairly recently, or fairly soon after this action was started. And you do have Ms. Fellows' guardian ad litem report and recommendations relative to that. As my client explains to you, Lexi is learning her own life skills. She's learning how to manage her money. She is going to have automobile expenses or automobile insurance expenses and the like, and this is all part of her learning process. She should be entitled to have the use of her own funds. Those, as my client tells you, were primarily birthday gifts from himself, birthday gifts from third parties, monies that she's earned and the like. So we're asking that the court order the immediate return of the $5,000. At this juncture, we have no idea where those monies are held or if in fact they've been fully deposited. We've provided with my client's initial declaration, the documentation that would be necessary for Ms. McGill to sign to remove herself from Lexi's account. We think that that's important because clearly we think that she's going to take this type of action in the future. It is concerning that she provided absolutely no notice, no correspondence stating her concerns about my client's supposed actions to remove monies, which again are totally unfounded. And then we have that coupled with the issue where my client has had his USAA visa for years. And currently, or at the time, that visa interest rate was 14.65%. He had also accumulated benefits under that account, or rewards as it were. Again, without absolutely any notice to my client, he goes to use the credit card and is denied. And come to find out, Ms. McGill unilaterally closed out the USAA visa, again with no notice. And my client lost his long-term credit card. He lost that lower interest rate. And obviously, we've seen interest rates skyrocket in the current financial circumstances of our country. And he also lost those reward points. So again, we're very concerned by her behavior. And we, to be quite honest, I don't know how, you can't recover his interest rate. You can't order the credit card company to reinstate him. You can't reinstate his lost rewards. So those are lost to him and to the community in violation of the court order. And coupled with that, you have a credit card that had a balance on it that has been closed out, which provides a negative impact on my client's credit report because of the closing of an account with a balance on it. So we're asking that the court enter a finding of contempt. We want the $5,000 returned back to Lexi's Navy Federal Credit Union account. The order provides that those are to be returned no later than July 10. We're asking, although at the time when I prepared my proposed order, I don't believe that your docket, and I think now your docket on the 11th is closed. Oh, maybe it's not. So we are asking that you set a review for July 11th at 1 o'clock to review and determine if she's complied with depositing those monies, if she's signed and delivered the documentation to remove her name from Lexi's account. We're asking that the court award my client attorney's fees and sanctions, sanctions at $200 and attorney's fees at $1,800, and that she comply with the orders in the future.
All right, thank you. Ms. McGill?
Thank you, Your Honor. Expressed in my declaration, that savings account was a college account. It was not a personal account for Lexi. We, as responsible adults and parents, opened this account when Lexi was 1.5 years old. We put her name on this account in case of our death, and it would be easier for her to have the account. The money that was deposited in that account was through our community monies. We also deposited in the money that we received from COVID. There were checks from my sister and from friends that were deposited in that account. And I've opened a custodial account to have the $5,000 deposited in. I have not deposited in that account yet because I know that Mr. McGill would accuse me of hiding the money. It is in my savings account, as I stated in my proposed order. Mr. McGill will spend that money with his desperation as evident by his actions regarding our joint credit card. Mr. McGill intentionally made frivolous purchases and also added $3,000 of his attorney fees to our credit card. I mean, that's common sense. You don't do that sort of thing. He just wanted a reaction from me and he got it. I had no choice but to close out the account. If he would have been paying $200 as ordered by the court, it would have been paid off, and then we wouldn't be here today. Mr. McGill's maintenance. So after that was closed, I couldn't take my name off that account because there was a balance. And if he would have paid it, then there would not have been a balance left on that account. Mr. McGill saying he didn't know he had to pay $200 a month is just plain laughable, Your Honor. His attorney should have gone over that court order with him to explain what it was that he needed to do. He didn't pay it. There were months that he didn't pay anything at all, and they got a $25 fee for that. It affected my credit score also. I had no choice because I didn't know what he was going to do. Our credit balance, our credit was $16,500. He was going crazy spending money out of that account. And I was afraid of what he was going to do with the college fund for our daughter. So it matters in my own hands. And I did that because I'm protecting that money for our daughter's college fund. He had no reason to be spending on that credit card. It was our joint credit card. He has his own credit cards that he could have done that with, and he didn't. So I'm not understanding what the whole situation is here and why he's crying foul when he's the one that did this to himself. It doesn't make any sense to me whatsoever. And the thing with his maintenance that he says that he was reduced, he actually said untruths to the courts to get that done. And that will definitely be coming out in our divorce trial. This time, there's no hidden catch-22 for Mr. McGill to hide under. And regarding my spending, those monies that were taken out were at the ATMs. For them to say that that was all used in gambling is just crazy. Let me get this here real quick. Yeah, the money is taken out of the ATMs. At the casino on Mondays, they have Senior Citizen Day, and they give us all seniors a free gift. And while I'm there, I use the ATM. My bank is in Olympia or in Lacey, Washington. So I just take money out for spending money, for my entertainment, for gas, to pay my rent. I've been paying stuff cash here lately because I feel like Mr. McGill's always tried to control me, and this is my way of not knowing my money is being spent at. It's just my way of getting my self-control back. So I'm not understanding any of this stuff. So that's why I want the court to order him to pay the $7,000 on the credit card. He put $5,000 within 2 months on that credit card. $3,000 of it was for his attorney. He spent $552 at Walmart.com, $43 at Walmart, $156 at Walmart, $245 at Depot. He spent $767 on service and parts. It's like that he brought this on himself. And then another $430 on beekeeping supplies. I mean, it makes no sense. It was frivolous purchases from the very beginning. And that's about all I have to say on that, except for them to put all those ATM things under gambling is just ludicrous. Thank you, Your Honor.
I guess I'm a little bit concerned. I don't see anywhere, and maybe someone can point it out to me. But my understanding was that Mr. McGill was allowed to use this joint credit card in the financial documents that were filed. And I've looked through the documents filed by Ms. McGill and the documents filed by Ms. McLean. To be very frank, Ms. McGill, attorney's fees on credit cards are something I see every week. That's not weird. If he was making payments on it and that was his account, even though your name's on it, I don't, and I'm going through what you filed. And if you could point out what page there's a late fee, I'd like to see it. I don't.
Oh, you mean on the credit card fee? On the Visa?
Correct.
Okay, that is October 14th, 2022, $25 for fee and charges because it was a late charge.
Okay, so 7 or 8 months after a late charge, you decide to unilaterally close someone's account.
No, Your Honor, I closed out this account because he was spending money on it like crazy. It's our joint account.
The request is going to be granted. You're in contempt, ma'am, and I don't know how you don't see that. You just completely closed someone's account.
It was
no reason whatsoever.
Too.
I understand that, but
okay.
I see that he has use of that account. He's paying on that account. If there's a late fee from October, I'm sure he's taken. I don't care what. Maybe at trial, it's going to matter what everybody's spending their money on. But frankly, you hurt yourself by closing that account because now the interest rates are more of his money is going somewhere else and potentially not to your daughter or to you based on whatever the outcome of this case is going to be. So I'm going to make a finding of contempt. I'm also going to require that $5,000 be transferred back. Frankly, looking at both of your accounts, if you have the money to spend, I don't know that frivolous things, if he wants to keep bees or if he wants to repair a car, I don't have a problem with that as long as he's paying for it.
Right,
but it's not hurting anyone else. I don't care if you go to Mr. Bill's for $500 a month, if that's what you want to do. I don't care.
I understand.
But that $5,000 is going to go back to Lexi McGill's account and in its entirety. I'm not going to order a civil penalty at this phase. I am very concerned, Ms. McGill, though. This to me is, I know you feel the exact opposite, but this to me is a very blatant and direct violation of the court's orders to just unilaterally close an account, very much to the detriment of the petitioner in this case. So I am going to make a finding of contempt. I'm not going to impose any civil fees. The $5,000 needs to be, I'm talking, ma'am.
Okay, I'm sorry.
For a very long time.
I apologize.
So I'm not going to impose a civil penalty. I am going to impose the lawyer's costs and then the transfer of the money. I am not here on the 11th. I think we do have space on the 11th to do a review to just ensure that that was taken care of. So we'll set it for the 11th.
Your Honor, I'm out of town on the airplane. I'm out of town on that day.
If you've done what you need to do, then it's okay if you're not here. So as long as everything is that money, really, it's just a review to make sure the money was transferred back into her account.
Is the court also ordering that she sign the release to remove her name from Lexi's account? That's at paragraph 11 B.
Why don't you just close that account out?
Clearly, you're not concerned about the benefits of some of the accounts with Navy Federal Credit Union and USAA. So I don't want to just close that account. I am signing the order as proposed, apart from the civil penalty.
That matter's ready.
Okay.
Thank
All right. Good luck, everyone. We'll
So
see you on the
in
11th.
this matter, for the record, I'm Chelsea Baldwin. I represent the petitioner Cameron Gibson. There's a couple different things on. The two main things are to review the sale of the family home, and the second is regarding the restraining order. The responses to both weren't filed until, or received at least at my office, until Friday at 4 via email. That means we've had no time to respond to them, which is not appropriate. So the opposing party is no stranger to the law. She works in the legal office. She's fully aware. And regarding the home sale, the court ordered that she was supposed to have responded timely. The court had set that matter over for a month. So here's what I'm asking that we do. I'm asking the court address the home sale. That's been pending since I believe March. So that should be addressed today. As far as the restraining order and the child issue, my client does need to respond to that. And I think that that's appropriate that my client have the ability to respond. I'm asking that we set that over to the 11th where, shoot, the court's not here on the 11th. We are already set on the 11th for a contempt. The court could set your preference to the 11th or the 18th. I don't have a super strong preference. So that's my request is we deal with the home sale issue today. We set over the child issues to another date so that my client can file a response.
All right, nice. I would assume Ms. Gibson will want to, well, I know that there was a supplemental report filed by the GAL requesting change in supervision, or excuse me, visitation. Is that something you want to pass as well? Or do you want to deal with that today, Ms. Baldwin?
I think that's really part and parcel with the child's issues. So, so I would sort of package all the issues associated with the child together.
So Ms. Gibson, my Odyssey is not working very well. This is the first opening it today. Yesterday when I looked, none of your information was in. I looked at it yesterday at 2:36 p.m. and there was nothing in Odyssey. So between yesterday at 2:36 and today at 2:33, I didn't look again. I've been in court. So I haven't had an opportunity to review any of the responses, and it looks as though there were some declarations from other individuals that were filed as well.
Yes, Your Honor, if I may.
Sure.
Okay. At our last hearing, you indicated to me that any responsive documents that I had for today's hearing needed to be submitted to Ms. Baldwin's office by Friday. I submitted those to her office on Friday. I actually showed up earlier Friday afternoon to deliver documents to her office, and the office door was locked. So there was probably like a 20-minute delay between when I tried to physically drop off documents to her office and when I was actually able to get them to her office because the door was locked. So the indication that I didn't file timely, I filed it by your deadline that you gave me. Also, I understand if you haven't had an opportunity to review the police report that I filed under seal relating to all of this. Had Ms. Baldwin and her and her client, if they had wanted to file any sort of response to the report, they could have freely obtained the report. That's the only reason that I even knew anything was going on. I've not had any contact with the GAL. I've sent her a handful of emails trying to inquire status and find out information from her. I didn't believe that I would get anything from Ms. Baldwin's office. But petitioner was told about the interview. It was conducted now 3 weeks ago. And if you would like to look in the report that I filed, I believe it's page 6 of that report. The officer indicated to Mr. Gibson the findings, or non-findings rather, of the CJAC interview. So
I don't want to get into the meat of the argument unless we're going to argue.
Okay.
No, so, I understand. I guess
Ms. Gibson, let me talk for a second here. In reviewing the minutes, what you were to file by Friday was the refinancing of the home, not 7 other declarations that have to do with different things. So I just reviewed the minutes from the clerk, and you had until Friday hold on, let me get back to it. So clearly there's a lot of other stuff that you filed that deals with a lot of other things. We were on today initially for a review of the ability to refinance. So when we were in court last, and I said you could file things late or get things late to Miss Baldwin, it was for that specific reason, not for all the other reasons that have cropped up in the meantime. So with me not having reviewed them, I don't know how much time Miss Baldwin's had to review them. Some of those issues we will not get into today. That's just the way it is. We can get into the refinancing, and if you did file something specifically in regard to that, I can look for that and try to review it.
I did, Your Honor.
Okay.
I apologize.
Was it under seal, or was it just like under a financial record, or was it just?
I addressed it in my declaration that I filed. I also, oh no, I believe it's just in the declaration. I filed it on Friday. I also addressed a bench copy to Your Honor when I filed everything on Friday. So I apologize if that didn't make it to you.
So Ms. Baldwin, since you've clearly had an opportunity to review this, thank you, Ms. Gibson. Since you've had an opportunity to review this, what is the position of Mr. Gibson on the refinance? And I'll listen to you and kind of look at what I have here.
Very good. So the easiest thing to do is honestly to just look at the Exhibit B that she provided. So the court was very clear in its order. The court said you have to refinance at $400,000, which is the value of the home, and that you had to refinance sufficiently to withdraw half the equity. So you have to refinance essentially the existing debt. Half of the equity in this home is over $200,000. They only owe $180,000. It's a $400,000 home. That means each party's equity, their 50% share would be $110,000. And again, at that $400,000 total value of the home. When you look at the Exhibit B that she provides, it fails on every level. So the first is that it is not a loan approval or an offer or an acceptance letter. It's none of those. It's once again just a person in office at a bank office clicking through, okay, 30% at this rate, at these dollars. So it fails there. This is not showing she can actually refinance the home and that any bank has accepted her as far as being able to get a home loan. Second, she set the home value at $350,000, directly contrary to your order. The $400,000 is even in the clerk's minutes. So she's not even trying to get the numbers correct. So fails there. And second, the offer the materials that she provided shows a cash out of essentially $9,000. That is miles away from the $110,000 she would need to cash my client out for his half of the equity. Again, in this case, the court was very clear on what she had to do by today. She's unable to maintain the home post-divorce. She cannot cash out sufficient equity of the home that would be necessary. The court already ordered on May 30th that if she couldn't provide these parameters, the home will be sold. So the court's already ordered, hey, if you can't provide that you can refinance with these parameters, we're selling the home. That's the end of the story. So in this case, we're there. I also want to remind the court that this has been pending since March. So this is not a new issue. She's had an exceptionally long period of time to try to get this done, and she can't because it's not possible. She does not have the debt to income ratio, and that's even in like one of the emails she attaches from the fellow at the bank. It's hearsay, but nonetheless, it goes to show she can't do it because even he's saying, well, debt to income ratio has to be this, and she's not there. She just cannot make this happen. The idea that we should further delay the sale is not appropriate. In this case, again, this has been pending since March. Summer is the prime selling season for homes. Both parties are entitled to maximize the value from the sale and not wait until sort of that prime selling season is over. So we are asking at this point, she's had since March, April, May, June, we're at the end of June. She's had more than 4 months to get this done and hasn't. We're there. It's time. So we're asking the court to order that the home be sold. It should be placed on the market immediately. We're asking it to be placed on the market and marketed by Sherry Ewald. That's not my client's pick. That's my pick. Sherry Ewald has done work for Ms. McLean, Mr. Zandy, Ms. Bliss. I think every high quality attorney would testify or recommend her. So that would be my request. I don't want to delay in choosing an agent. Everyone should cooperate with the agent and the home should be placed on the market immediately. There's just after 4 months, there's no reason to continue to delay.
All right. Thank you. Any response to that specifically, Ms. Gibson?
Yes, Your Honor. Thank you. I did attempt to refinance, as I stated in my declaration from the loan officer that I spoke to. I was not allowed to complete the application process without court approval. Petitioner is still on the current mortgage that is being paid. So the loan officer, without any sort of written indication from the court that I could finish the application process to refinance the home solely in my name, they couldn't do that without either, as I said, court approval or authorization from petitioner. And I did what I could. Ms. Baldwin's indication that I'm not maintaining the home is inaccurate. The mortgage continues to be paid timely. The second mortgage continues to be paid timely. There's no issue of the home falling into foreclosure. I'm maintaining the home. I'm doing all of any sort of necessary repairs on it as I'm currently living there. In addition, none of the other community assets related to the parties have been settled or agreed upon. So I believe that this should be in consideration of all of that, whether it's by agreement of the parties or at trial. I understand Ms. Baldwin and petitioner's claim to the equity of the house. That makes sense. He's on the mortgage. But there's also other community assets that I have or should have equal access to that I don't. I understand if the court is going to order that the home be sold. In that instance, if they feel that the assets can be divided, I personally don't see how, since we've not dealt with any of the other community assets, why this needs to be taken care of separately when I'm continuing to make payments timely and everything is being kept up. I don't see that the home would be losing any sort of value between those times. If anything, it continues to accrue value as time goes on. I do ask, though, that if the court is going to order that the home be sold, that it be delayed at least 75 days to allow me to find time for other housing. The rental market right now in this county is very limited and rental costs are very high. So putting the home on the market and immediately having to try and move out of something without having adequate time to find other housing presents a lot of complications, including getting time back with my children, which I understand we're not talking about right this minute. Additionally, I would ask that each party get access to $20,000 of the proceeds of the sale of the home. I'm going to need access to that equity in order to find another situation and any other expenses that arise out of being forced to move. So I would ask the court hold off due to other community assets not being dealt with at this time, or if the court's going to order the sale of the home, to delay 75 days to allow me time to find other housing accommodations.
Very briefly.
Yes, yes, Ms. Baldwin, hold on. Ms. Gibson, can you respond to why it was set at 350 versus 400 in the request for the refinance?
Oh, that was an oversight with the loan officer. I did speak to him and tell him that the assessed value through the court was $400,000. So I apologize that that was missed on my behalf. I can, if the court would like, I can get another thing from Mr. Alexander at the $400,000 assessed value rate. During mine and his phone conversation, I did indicate that the court set it at $400,000. So I apologize that it was inaccurately depicted in the paperwork that I provided.
And I'm assuming based on that, your comments, that he indicated that that would not be an issue. Is that correct?
I'm sorry, I don't understand the question.
Like you would still be able to do this process if it was 400 versus 350?
For the assessed value of the home, yes.
Okay. All right. Thank you very much. Ms. Baldwin,
Yes.
Go ahead.
What she means when she says he can do this process, he can run the numbers. He cannot approve the loan. Turn to the page after the mortgage passport page. So her exhibit B has 2 pages. First page says loan program scenarios. Second page is an email. Email is from the loan officer. Says, hello, Jill. Next line after that, our guidelines through Fannie Mae cannot exceed 45% debt to income DTI, max of $49.99 with 6 months. And then it goes on. It's saying you can't do this right now. If you look at the last line before I sent the scenarios, it says total payment of $1,507. Again, please keep in mind, this puts the numbers over 45%. She can't refinance it at $350,000. She certainly can't refinance it at $400,000. She can play with the scenarios. We can all play with math, but it doesn't mean that it'll be approved. This idea that you have to have court approval for a loan application, simply not true. You might need court approval to go through the process to finish and actually get a loan, but not to do an application. Similarly, I did what I could. The 350, if you look, he says down below, I sent the scenarios for your review. Means there was more than one. There's probably one that's at 400,000. She just doesn't want to show it or provide it here. And again, even this email says there's a very limited cash out. So this is, again, $9,000 cash out when the court said half the equity, which is $110,000 minimum. So at this point, we're there. The court's given her month after month after month to provide the same information. She hasn't been able to do it. The court was very clear giving her this last 30 days. She still has not complied or provided the information necessary. The court should order the home sold. 75 days puts us essentially at the end of August. That's not appropriate. Homes aren't sold one day and sold the next, type of a thing. The process still takes some amount of time. That gives her some amount of time to find a new housing situation for herself. As far as funds to both parties at the sale, I think that should wait until the home is sold. We can address that later once the home is sold. I think that's the most appropriate thing. The hearing coming up on the 11th is contempt regarding non-payment of children's expenses. So I think we should address more financial issues than just that all at the same time, again, after the sale.
All right. So as far as I am going to order the house to be sold. And I am going to delay it slightly. I'm not going to give the 75 days. I'm going to give 30 days for it to get on the market. And as with the interest rates being what they are, houses are moving, but they aren't as moving as fast as they have been. So I'm assuming Ms. Gibson will have more than 30 days to prepare for this. As far as any distributions to the parties post-sale, I'm happy to consider that, but I don't want to dictate what those would potentially be at this point, since we don't know where we're going to fall with the home sale. I would absolutely be willing to consider a disbursement of some of those funds after the sale of the home to help the parties as we continue to move through the process. As for, and I don't have any reason at this point to say that Ms. Ebald is not appropriate to list the home. As for the two remaining issues that we need to deal with, so that have to do with the children, I'd like that done as quickly as possible. The 11th is available. I'm not here, but there's space on that docket. I'm not sure who's covering that docket. Potentially a commissioner, potentially another judge. It just would all depend. Then the next available for me would be the 18th. So I don't know, Ms. Gibson, do you have a preference? I'm sure the parties want the sooner the better with dealing with the children. But I just want everyone to be aware on the 11th, it would not be me. So any preference from anyone?
I prefer consistency, but I'm fine either way.
Ms. Gibson, do you have a preference?
Yes, Your Honor. I would prefer for this to be heard as soon as possible.
All right. So we'll set it for the 11th of July, 1:00 p.m. And I believe that'll close that docket, Ms. Terry. So I'll give the last spot on the 11th to this matter. And I'm sure whatever judicial officer that is here will be more than prepared to handle the matter and address the parties' concerns and make a determination. So we'll pass the other two. And is presentation for the home sale order on that same date work for you, Ms. Baldwin?
Can't be the 11th because you won't be here.
Oh, that's right.
I could do it. So I'm happy to pump out an order. And if Your Honor has space on your presentation docket this Friday, I'm happy to do it there because that's fairly straightforward. Otherwise, I think that puts us to the 18th. And then, so we can address that. And then I have one or two more quick clarifications.
I have court at 9 a.m. and I already have two presentations on this Friday. So if it can be, my hope is that it be agreed. I've made, it's pretty short order. If not, then I guess we'll review it on the 18th. See if we can do I think the 18th, let's just set it for the 18th at 1 p.m.
And so just on clarifying, the home needs to be placed on the market. And I'm just picking July 27th because that's 30 days out. But everyone has to sign the paperwork, sale agreement, those types of things prior to that. What I don't want to do is nothing happens until the 27th as a method of delay. So essentially everybody needs to do all the prep work, but the home will actually be sort of listed on the MLS on the 27th.
No later than the 27th of July. Yes.
Okay, very good. And then the court's issuing that regarding the children, the current orders are just going to maintain until the 11th.
Correct.
Okay, very good. I think those are my only questions.
Okay. All right. Well, good luck, everybody. We will see. I'll see you on the 18th, and then the other matters will be heard on the 11th. Face was just disappointment that I wasn't calling her case. Is that probably what it was? Okay.
She's somewhat of a complainer come Tuesday afternoon, Judge. it's okay.
Understandable. All right, so we're here on temporary orders. And we set this over for a response, and I saw yesterday afternoon late a response from the respondent in this case, and the response was essentially a proposed parenting plan. Did you receive that, Mr. Zandy?
Not to the best of my knowledge. It has not made it to my file or my desk in my preparations this morning.
Okay, so there's and I'm sorry, there was also a child support worksheet proposed. So they were essentially proposed orders that were filed as proposed orders, nothing else. Ms. Svalenka, was there anything else that you filed?
No, that was it for now.
Okay. Mr. Zandy, do you want to move forward?
I do, Judge. This is a case that was set over from May 30th to today's date, enabling Ms. Svalenka to have time to review my client's submissions as well as enter a response. And as noted, I haven't seen anything as of this point. This is a case that's been kind of hanging on in wait and see mode. Ms. Svalenka, to the best of my knowledge, presented at the last hearing that she was inpatient treatment. It appears that she did receive our documents at that facility. Basically, what my client's asking for, I think, is about the only thing the court can do at this juncture. This is a 10-year marriage. Born as issue was Hunter. I think what my client lays forth in his declaration is the honest facts of this case, and he's readily admits that both parties have had past substance abuse issues. But while he's taken meaningful strides to overcome his, and he acknowledges every day is a challenge, the same cannot be said for Ms. Svalenka. Hopefully, now that she's been in treatment, she can turn the corner on that. But again, this is an individual who has not only the substance abuse issues that are still trying to overcome those, but as well as now some criminal charges and other various aspects of her environment that are somewhat open-ended at this point. Hunter, since the separation back in March, is doing very well. He will be, I believe, a 4th or 5th grader in the fall. Goes to Butler Acres, resides with my client in the family home. And is doing quite well through the process and through the change. And part of that, one can only imagine, is what Hunter was exposed to inside the home, between the issues between mom and dad, culminating in Ms. Svalenka's decision while under the influence of drugs to try to run my client over in the family car, thus picking up the criminal charges. That, again, can't be understated. Again, that has an impact on the child because children are very receptive to the fact of what's going on in their environment around them. And again, to the best of my knowledge, mother has had very little contact with Hunter since March. We believed initially she was residing with a friend in Battleground. Come to find out, she was in the treatment facility. It now looks as though the address she gave us was a Castle Rock address. We don't know what the long-term plan is for her. We don't know where she's at in that treatment. We don't know what's happening right now in the criminal investigation, or excuse me, the criminal case. My client believes that is still pending. There's been no resolution to that. I'm assuming that the inpatient treatment could have been court ordered to the criminal action. Again, I don't know that. I don't have any information or documentation to verify that. But nonetheless, mom needs to get healthy. My client details for you what he's done since volunteering to go to inpatient treatment. He continues to work that program. He continues to go to weekly therapy. He continues to go to Narcotics Anonymous, and he's met with a mental health counselor at least once a week. And again, the impact of that on Hunter is that the child is doing markedly better now in June than he was last fall. And that's the positive. We have a lot of questions in this case. We have a lot of uncertainties and unknowns. Hopefully in time that will come out. Hopefully both parents will make good decisions. But again, if we take the parties where they stand today, and that's what I believe is required of the law, my client is making good decisions. He's providing a stable home for his child and is in a much better position to have custody of this child, unfortunately, than Ms. Svalenka is. I don't know what is in her proposed parenting plan. I don't know if she's proposing on the custody side of that or visitation. From our perspective, we want to see some kind of proof that she's doing what she's supposed to be doing and that she's not under the influence of any illicit or illegal drugs. Again, this is a history where she would not be able to be sober for very long at all. As my client details for you, maybe a couple of weeks, and then she would quite literally binge to the point of major concern. She has not been able to keep a job. It's impacted her ability to have and maintain relationships. And again, that's things that we want sorted out, or some kind of confidence that those are being addressed effectively and on a long-term basis prior to just allowing any kind of visitation that's unfettered between Ms. Svalenka and Hunter. What we're proposing is simply that visitation be professionally supervised. Our suggestion is reconnecting families in Longview. I think that's probably the closest facility to both parties if she's in Castle Rock and my client's in the family home in Kelso. And again, that can happen. My client doesn't want to cut out contacts between the child and his mother. We just want to make sure that it's in a safe, sterile setting at this point, given all the questions and concerns that we have and unknown answers that we really need a resolution on before we go too deep in this and just assume that Ms. Valenka is making good decisions. That's the parenting plan side. If you look at the financial side, again, I think it's pretty clear to see my client was historically the breadwinner. He acknowledges that. My client makes very good money as a computer software technician. We provided you under sealed financial source documents proof of his earnings. And that's great if you just take the face value of that. However, we've also provided you information, again, under sealed, that shows the tremendous amount of debt these people have accumulated. And again, that is significant. My client is essentially saying, I will pay all of the community debts, which he's doing. He'll pay the mortgage, he'll pay the credit cards, he'll pay his student loan, he'll pay the auto expenses, he'll pay all of that different stuff that's associated with that. Doesn't expect child support in return. It's just asking for an offset on the maintenance. Doesn't sound like that's disputed. But nonetheless, that's our approach, and that's our suggestion for the resolution, at least on a temporary basis, until we can gather more information on this. A GAL, this is probably a case where appointment of a GAL would be appropriate, given the history and given the current circumstances. My client, again, details for you that he's willing to take 90% of that obligation. This is, again, not about cutting mom out. This is just preserving Hunter's best interest and safety so that Hunter can have and be exposed to two parents who are making good decisions and not under the influence of any illicit drugs. That's the goal of this, where we're at right now. My client proposes each party essentially keep the property in his or her possession, including the automobiles. My client will maintain the mortgage, the taxes, and the insurance on the family home on Crystal Court in Kelso. And again, setting up some kind of contacts between Hunter and his mother is certainly appropriate. We would just like to see that be, again, taken in a conservative approach with the professionally supervised visits, which we think makes the most amount of sense.
Ms. Svalenka, is there anything else you'd like to state at this point?
I would just like to state that a lot of those accusations are very inaccurate. I would really like the chance to have the time to find a lawyer. I completed treatment on the 13th is when I got out, which I went to voluntarily. Prior to that, I had also voluntarily put myself into IOP, which I had been going to, and going to meetings and going to all of it and passing UAs, etc. beforehand. I would say that Hunter he's a really good kid, and I would really like to spend more time with him, but it's really unfair to say that one of us is either better or worse than the other, since we both have been sort of in this situation together. I would say that Christopher only became sober 3 months or so before I did. I don't really think, in the grand scheme of all of this, that's a huge gap of time to be caught up. And I did this all on my own without any court order, etc. Also, I did not attempt to run him over with my car. That's not true at all. I would really like the opportunity to acquire an attorney of my own. I'm doing the best that I could with the time frame of all the paperwork that I've been given and due to being an inpatient before.
Thank you. First and foremost, I appreciate that you put yourself into treatment and that hopefully you successfully graduated that treatment. That's not an easy task. So I just wanted to acknowledge that.
Thank you.
What I'm going to tell, so I'm going to just kind of talk a little bit here. Mr. Zandy, the parenting plan that was proposed, so as I stated, it's simply a proposed parenting plan and simply a proposed child support worksheet that were filed in response. And I understand that she's representing herself. Essentially, it's she's wanting sole custody and alleging 7 different 191 factors, actually 8, I apologize, 8 different 191 factors, and requesting supervised contact only between your client and Hunter. So it's essentially kind of an opposite plan as what you're proposing, and that's up to 2 hours. And
does it look like she just kind of cut and pasted or copied what we had in our proposed plan from a couple months ago? Is it?
No, I wouldn't necessarily say that. It's just she's asking for professionally supervised up to 2 hours once a week, arranged through a professional agency, that he get an evaluation for substance abuse and mental health and domestic violence, and that there be a UA or hair follicle test done before any visitation. So just since you haven't seen that, I wanted you to be aware of what she's requesting. And then the child support worksheet lists him at gross of $18,200 and her at 0, with a final request, a transfer payment of $1,573 a month for support. So So that's where we're at. Here's the concern. So there's a lot of things going on. One, first and foremost, I will appoint a guardian ad litem. I think it's appropriate, given the kind of cross claims that have been laid out here, more so by the petitioner. So if I could have Ms. Terry, the next three names. Mr. Zandy?
What was, Miss Terry, what was that first name?
Heather Kell.
Okay, I'll strike Heather.
Right. And Ms. Svalenka, you can accept the next guardian ad litem, or you can strike one if you choose.
I'm not entirely sure what that is.
Okay. I will appoint Amy Turnbull. So it's just a matter of who will be the person, kind of the independent investigator into the case for the best interests of the child. So I'll appoint Amy Turnbull as the guardian ad litem. I'm not going to enter any child support orders at this point in time. I will adopt there was a temporary order. I have a proposed temporary order allocating debts and expenses. So petitioner will be responsible for mortgage, the insurance and utilities on that home, the taxes, the two vehicles that are currently listed. It looks like Ms. Falenka, do you have the Hyundai Tucson?
I do.
Okay, so you'll retain the Hyundai Tucson. Mr. will retain the Acura. Those car payments will be taken on by the petitioner. Looks like the debts, all but the student loans, are being requested to be taken on by the petitioner. Ms. Falenka, do you have any ability to pay your student loan debt?
Currently, Christopher has been paying my student loan debt. He's been making payments on it since forever I can remember. But I don't have any source of income right now, as I was a homemaker and sort of got displaced from that. But I'm currently looking for a job, and I'm also a full-time student, so hopefully soon.
Okay. Well, here's
Yes, Judge.
Sorry, go ahead.
Sorry, I didn't mean to interrupt. I was just offering maybe some clarity. I think she could contact the student loan provider and ask that be. I think we're still on a lot of that COVID relief. The fact that she's going through a separation, I don't think a lot of those federal loans, which I believe is what she has, I think you can defer those currently. So that was the suggestion why she pay her student loan, is because I think those can all be deferred.
If I recall, it states in the letter that Christopher claims that he can't access them, which is also untrue because he's been the one paying them. But I can try to defer them.
All right. Here's what I'm going to do. I'm going to have, I would ask the respondent look into trying to defer those. And if you can, let Mr. Zandy's office know as soon as possible. In the meantime, I'm going to ask that the petitioner pay the student loans for the next 3 months, or until you're notified that they have been deferred. So that gives Ms. Svalenka a little bit of grace period to address that issue, and hopefully find employment. The petitioner also take the auto insurance. Will enter a temporary order, so nobody should do any destruction to any property, get rid of any accounts, change any medical insurance, health insurance, car insurance, anything like that without prior court approval.
Does that mean that the credit cards that I've been canceled on, that he shouldn't have done that? I've been sort of without funds. He's been slowly but surely cutting off all of my credit cards. So been sort of, not great.
Any response, Mr. Zandy, to that?
That's the first I've heard of that. I have no idea.
Okay. So there hasn't been an order until today. There's going to be an order starting today that there's no change to any accounts, that there shouldn't be any spending that's not necessary by any of the parties from any joint counts, no charging up any credit cards or any nefarious activities, all the standard language in those orders. As for the parenting plan, we have two very distinct accusations, one from petitioner, one from respondent. Petitioner is in his declaration pretty honest, saying that this is a problem that I've had as well, claiming to be in a different situation than respondent. Both claim domestic violence, assaultive behavior, substance abuse, abusive use of conflict, just to name a few of the 191s. I'm going to reserve on 191s right now. But frankly, the only proof that's been put forward of any concerns that with any evidence is by the petitioner. An allegation of domestic violence in a proposed parenting plan with nothing else doesn't really help the court out. So I don't think I can rely on that. I will make Mr. the primary custodian at this point in time. I'm going to authorize up to 4 hours a week of visitation. And I would ask that those be supervised if there is, I think 3 months with a 10-year-old, I don't know that we need to go through a professional supervisor. If the parties can agree on a non-professional supervisor, the court is fine with that. If they can't, then reconnecting families is fine. So up to 4 hours a week. If we get an interim GAL report, I'm willing to reconsider the visitation type and how often that is, but we'll ease into it a little bit here. I don't really know if the parties are able to communicate. But not reserving on 191s, I'll make all major decisions joint at this point. Dad obviously would be in control of the day-to-day decisions as the primary custodian. Standard language with regards to moving and relocating. And there is a proposal for communication on Our Family Wizard. Miss Svolinka, there's an app available and it's free. You don't have to pay for it, but you put it onto your phone and it basically monitors and keeps track of different things that have to do with the child. So updates on, you can communicate with each other and it's all kept track of. So if there's no abusive language or manipulation, that's all recorded and kept track of. But you can also, I think, calendar certain events through that app. So it's kind of a way for the parties to communicate about a child without having to directly speak to one another. So I'll authorize the use of Our Family Wizard. Because you're currently representing yourself, you can contact Mr. Zandy's office and have a conversation with his office about some of these orders. And once these orders are entered, you can get copies of them from the clerk's office. So you can review all that and take it to an attorney if you do get an attorney hired. Since we don't have those orders, Mr. Zandy, and I apologize, I don't have them here. How much time do you need for presentation?
They're done. So probably the 18th or a Friday prior to that would be fine. I'll mail them out to Miss Svolinka's Castle Rock address that she provided my staff last month. I'm assuming that's where she's at. Just one issue for clarification. So the joint decisions in the Our Family Wizard, one of the things the court had questions about in May was whether there was a no contact order through the criminal case. I just don't want to get into somebody violating, which would be the wife in this matter, any terms under the criminal cause number related to a no contact order. So we'd have to kind of massage that or at least tweak that so that we could not get anybody in further trouble. And I don't know. My client is under the impression that there is such an order, but Ms. Svolinka, was my understanding at the last hearing, didn't think there was.
May I say something, Your Honor?
Sure.
So I double checked with the police department. The no contact order is against Christopher, but not including a Hunter.
Correct. But if there was communication between the two of you with regards to Hunter, that could be a violation of the parenting plan.
No, it was
of the
just
protection order. It could be a violation of the protection order is what I meant, not parenting plan. So thank you for reminding me that, Mr. Zandy. Is your client able to, are there parties that your client would be comfortable supervising any visitations?
In my last discussion with him, we talked specifically about that, and there were some third parties that there were some third parties that he was quite simply not agreeable to, which is what kind of led us to the reconnecting families. If it is a professional supervisor, we don't have to worry about these two having contact and violating orders because that's all done through reconnecting families. I could talk to him about a potential third party. I believe the individual in Battleground, I don't remember the name offhand, was an agreed person that he didn't have any issues with. I don't know Ms. Svolinka's response to that, but it is possible. I guess in the order, I'll just draft it. I'll talk to him again and get some names, and I'll include those names in the order along with reconnecting families as kind of a baseline for visits. And then we can kind of go from there and our bases are covered. I just don't want there to be, the two of them going back and forth in a text communication or
Right.
direct message application, and she violates that, and we're back to kind of square one. I don't think that anybody wants that.
Right. And I agree. So I appreciate you pointing that out. So let's just omit at this point the Our Family Wizard, and Mr. Zandy will be the current wizard between these parties.
Also, just to update, the address that you had was for the treatment center. I'm currently staying at the place in Battleground with Joshua. I believe that's who you're talking about, him being an okayed person, as he's been the person, I guess, who's been supervising all of our current weekend visits between Hunter and I. So.
Okay, good. All right. So we'll set this to July 18th, 1:00 p.m. for presentation. If those orders are returned signed, Mr. Zandy, or you, there's any communication there, we can strike that, and I'll sign those ex parte.
You want to adopt the 90-10 percentages on the GAL?
Oh, yes. Thank you. I did write that down. So 90% to petitioner, 10% to respondent.
And do you want to reserve on joint decision-making for the time being until we get input from the GAL, given the?
Yes, given the no contact order, let's reserve on that as well.